Hi guys, welcome and welcome back to my YouTube channel. It's your favorite lawyer. Today it is not mystery law and makeup blah blah blah. Today we are basically focusing on the law, what the law says about marriages. And today we are going to be looking at the topic nullity of marriage. And under nullity of marriage, we have void and voidable marriages. So when we talk of nullity of marriage, nullity of marriage is different from a divorce, from filing for a divorce, is different from restitution of conjugal rights, is different from judicial separation. When you talk of nullity of marriage, you are saying that a party is coming forward to question the validity of that marriage, to question whether that marriage is real or not, to question whether the marriage is in existence, whether there has been any marriage at all in existence when you talk about nullity of marriage. So most of the time it is always one party coming forward to say that I think something is wrong with this marriage. I think there is no marriage in existence at all. I think there has been a problem in the celebration of the marriage. Which this in turn brings us to the fact that marriage, when you talk about nullity of marriage, when proving the existence of a marriage, the actual ceremony of that marriage must be proved. When talking about whether a marriage in itself exists or not, the ceremony, the ceremonial aspect of that marriage must be proved. There must have been a gathering, at least the husband, the wife, and witnesses. Do you understand? So basically today I'll be focusing on void and voidable marriages. Why? Teaching you and looking at my laptop, giving you different cases on instances where there has been void and voidable marriages, and also what the law says on it. And as I've told you earlier, if you watch some of my old videos, you will discover that I said that most of my videos I'm just going to be looking at two acts that regulate marriages. We have the Marriage Act and we have the Matrimonial Causes Act of 1970. And the Matrimonial Causes Act is mainly dealing with issues that arise out of a validly conducted marriage. And it is also that Matrimonial Causes Act that we know if a marriage is void or is voidable or valid. So we are looking at void and voidable marriages. A void marriage is one that will be regarded in every court in any case in which the existence of the marriage is an issue and maybe the marriage has never taken place or can be so treated by both parties to tie without the necessity of any decree annulling it. What this is saying, that when you talk about a void marriage, you're talking about questioning the existence of that marriage, that there has been no marriage from start. Do you understand? So a void marriage is one that has never existed before. That is what the law says. However, a voidable marriage is one that will be regarded in every court as a valid marriage until there has been a decree, there has been a command from the court annulling such marriage. So a void marriage is there has been no marriage at all. You guys are just living together as couples. A voidable marriage is there's a marriage in existence, but however, until there's a decree from a court annulling the marriage will be said to be voidable. So a voidable marriage is regarded at law as a valid and subsisting marriage until it is set aside by the decree of the court. I hope you get that. A voidable marriage. Okay, so now the decree of a competent court, don't forget that. The court has to be competent. And so according to the case of Mbonu against Mbonu, what the court held was that a void marriage is one that will be regarded in every court in any case in which the existence of the marriage is an issue has never have taken place and can be so treated by both parties to tell without the necessity of any decree annulling it. That is to say that you don't even need a decree to annul the marriage. There has been no marriage in the first place, a void marriage. A voidable marriage can only be annulled by a court of a competent jurisdiction. I said that the other time, that the court must have competent jurisdiction. And also, in the case of a void marriage, it is not necessary to obtain a court degree because there's no marriage in the first place. Like I said the other time, for a voidable marriage, annul a voidable marriage, there must be a court decree from a competent court, from a court of competent jurisdiction. Why a void marriage? You don't even need any decree because the marriage is not in existence in the first place. So a marriage that is void ab initio cannot be given legal effect by the court or by the conduct of the parties. However, in the case of a voidable marriage, a party to it may, by his act, put it out of his power to obtain a decree of nullity. So now we want to talk about grounds for voidability of marriage. That is, some things you have to look at to know if a marriage has been void from the beginning. Number one, existing lawful marriage. Now, according to the Matrimonial Causes Act of 1970, the Matrimonial Causes Act has laid down some grounds to make for us to know that a marriage has been void from the beginning, that is void ab initio. So section 3 sub 1 sub a of the Matrimonial Causes Act of 1970 says that where either of the parties to a marriage is at the time of its celebration lawfully married to another person, such marriage is null and void. So if you can prove at the time of a particular marriage that either of the party, maybe the husband, the wife, is lawfully married to another person, the marriage is void ab initio. A marriage cannot hold. Now, I'll give you instances. For example, if you have previously gotten married to somebody under customary law, for example, you celebrated a traditional marriage with a lady, and it is a valid traditional marriage, there's been a traditional marriage with another lady, and you proceed maybe 2-3 years later or some months later, you proceed to get married to another person under the law. Another person under the law. A different person under the traditional marriage. Now another person, another lady under the law. Your new marriage under the law is void. Because what the law does is that the law actually recognizes a customary marriage, a traditional marriage. Yes, the law do recognize it, especially when it is done before a marriage under the law. So your marriage will be void ab initio if you've been married to somebody previously under the customary law, or a traditional marriage, then wants to get married to another person under the law. And the case in point is the case of Nwakwele against Buakwele. And this also leads to section 33 sub 1 of the Marriage Act. And I'll tell you what it says. It says that no marriage in Nigeria shall be valid. Listen to this. Where either of the parties at the time of the celebration of such marriage is married by native law or custom to any person other than the person whom such marriage is at. That is, if you are having a statutory marriage with the same lady you've had customary marriage with previously, you have no problem. Your marriage is valid. But if it is different set of people, you've had customary marriage with one lady, you are having statutory marriage with another lady, your marriage is void ab initio. Section 33 sub 1 of the Marriage Act states this. Now, Another case in point is the case of Osamoye against Osamoye. So another point to know that your marriage is void ab initio is where a person is married under the Marriage Act, purports to contract a customary marriage with a third party during the subsistence of the first marriage. Now listen to this. If you are legally married to somebody, to a lady, under the law, and without divorce, without doing anything to that marriage, you want to go and get married to another person under the customary law, the new marriage is void. You cannot say you want to get married to me now under the law. Say we are married now, and after some years, some months, you say you want to go and get married to another lady entirely under the customary law. Your new marriage is void because there has been a subsisting legal marriage. Now listen, it is necessary that the subsisting statutory marriage must have been contracted in accordance with the Marriage Act in Nigeria. So any customary law marriage with a third party is null and void. Is null and void. So when you have a subsisting statutory marriage and you want to get married to another person under the customary law, your new marriage will be null and void. Another thing is where a person who is a party to a subsisting marriage purports to contract another marriage with a third party, either under the Marriage Act or under a foreign name or under a foreign marriage law. So what this thing is saying that if you are legally married to somebody and you purport to marry another person again, it cannot work. Whether you are legally married to this person under the Marriage Act in Nigeria, or you are married to that person under a foreign marriage law, you cannot enter into another marriage again. The marriage will be void. Okay, for example, in the case of Oshodi against Oshodi, let me read the facts of this case to you. A wife petitioned for divorce on the grounds of cruelty and adultery. The respondent, that is the husband, contracted a valid marriage in 1954 with one Sikiratu under Yoruba Islamic law and custom pertaining to the Ahmadiyya Muslim movement in 1955. The respondent and the petitioner were married under the Yoruba native law and custom. The petitioner knew of the 1954 marriage, and all three lived together before the petitioner and the respondent left for England. In 1956, the petitioner and the respondent went through the English form of marriage. The respondent contended that the English marriage of 1956 was a nullity, and consequently the petitioner was not entitled to relief sought. The court held that the 1956 marriage was not celebrated in Nigeria, and as such, Section 33 sub 1 was relevant. However, the correct approach to problems of marriage under a foreign law should have been through the conflict of laws rules. Capacity to marry is determined by the lex domicilii of the parties. What this point is saying is that once you're married to a person under the Marriage Act or under any foreign marriage law, and such marriage act, especially when this person is married under a monogamous system. A monogamous system is when you're allowed to marry just one person. The subsequent marriage will be void. So another point is the issue of affinity, prohibited degrees of affinity and consanguinity. When you talk about affinity, that means they probably are of the same descent, they have common ancestors, so they cannot get married. And when you talk about the other one, that is consanguinity, they have relations that are married to each other, which will prohibit them from getting married. So, however, when you talk about this, it is possible that under some circumstances, it's possible for some persons who are prohibited by affinity to marry each other with the consent of a high court judge. So if you are prohibited by affinity, that is by same descent or ancestor, you can get the consent of the judge of a high court to get married. Another point that I would like to state is formal invalidity. That is invalidity by the lex loci celebrations. Now, the formal validity of a marriage is governed by the law of the place of celebration. So it is this law that determines whether the location rules as to form were complied with. That is, formal validity of marriage. When you talk about validity, it has to do with the law of the place. That is lex loci celebrations. That is law of the place where the marriage was celebrated. The marriage has to conform with the law of the place where it was celebrated. So a marriage that failed to comply with the form prescribed by the place it was celebrated is void. And this is in section 33 sub 2 of the Marriage Act, that a marriage shall be null and void if both parties knowingly and willfully in its celebration without compliance with some formality prescribed by this act. So if you don't comply with the laws, that is lex loci celebration, law of the place where the marriage was celebrated, your marriage is said to be void from the beginning. Your marriage is void. Another form is place of celebration. Place of celebration, this is really important. When I was in school, when I took a course under family law, they stressed this over and over again. Where you celebrate your marriage is very important. I'll state the places where a valid marriage is supposed to be celebrated. So a marriage under the Marriage Act must be celebrated, number one, in a registrar's office. In a registrar's office or a licensed place of worship, or a place prescribed with a special license. That is where you see people celebrating their marriage in a plane. They must have gotten a special license to celebrate their marriage there. Or when they celebrate it by the beach, they must have gotten a special license to celebrate their marriage there. Because if you don't celebrate your marriage in a registrar's office, in a licensed place of worship, that is a licensed church, or in a place where you got a special license for, your marriage is void. So a marriage celebrated in a place other than this will be void ab initio. Section 33 sub 1 of the Marriage Act. A marriage will be invalid if celebrated in a church that is not licensed. That's why I said the other time, a licensed place of worship. So you can go and celebrate your marriage in any church, but if the church is not licensed, your marriage is invalid. In the case of Bello against Bello, the parties went through a form of ceremony of marriage at the Celestial Church of Christ, Queen Elizabeth Road in Ibadan. The church issued them a certificate of marriage. It was adduced in evidence that the Celestial Church of Christ, where the marriage took place, was not licensed for the celebration of marriage. So the court held that the marriage was celebrated in violation of Section 33 sub 2 of the Matrimonial Causes Act of 1970, and therefore it is void ab initio under Section 3 sub 1c of the Marriage Act. So make sure the place where you celebrate your marriage is important. A registrar's office, a licensed place of worship, and any place you want to use, but with a special license. Another thing I want to look at is celebration of marriage under first name or names. A lot of people do this. So where both of the parties or any of the parties of a marriage that is celebrated under the act is aware that they are celebrating the marriage under first names, such marriage will be void, and that's the Section 33 sub 2b, Matrimonial Causes Act. So when you celebrate your marriage under false names, your marriage is void ab initio. Another thing I would like us to look at is celebration without a certificate or a special license. So for a church marriage to be regarded as valid, some of these factors must be complied with. Number one, the parties, or at least one of them, must have intended to contract a union recognized by the Act, and in particular church celebrating the marriage. So when you want to talk about whether a marriage is valid in a church, at least one of the parties must have concluded, must have willfully consented that I want my marriage to be celebrated under the act, a marriage that will be recognized under the law to be celebrated in this particular church. Another thing is there must be a belief that they are in fact contracting such marriages. There are some people that contract their marriage in unlicensed place of worship without, and they are ignorant of this because they didn't know that where they are contracting their marriage is not licensed. So if they believe that the time they were contracting their marriage, that they actually contracted a valid marriage, the marriage celebrated in the church will be regarded as valid. Another thing is, at least one of the parties will be ignorant of the failure to comply with the provisions of the Marriage Act. Now, for you to say there has been a valid marriage in a church, one of the parties must be ignorant that they've not complied with the provisions of the Marriage Act. Not two of the parties knowing that, yes, we've not complied with the provisions of the Marriage Act, but we decide to move on with this marriage. Another thing is the aggrieved party must give evidence in proof of the marriage and as to his or her intention to contract a valid statutory marriage. Sometimes the court, the law, look at your intention rather than the form. So what I'm saying is that one of the parties must give evidence that yes, I believe we were contracting a statutory and a valid marriage when I entered into this marriage, not knowing that probably the place is not licensed or the provisions of the act was not complied with. For example, in the case of Acquid K and against Acquid K, the parties were married on the 31st of May 1958 at St. Mary's Catholic Church, Port Harcourt, in the presence of a Roman Catholic priest and 2 witnesses. No notice of marriage was given in accordance with the Marriage Act, and the registrar's certificate was not issued to the parties. The priest, in fact, performed a Roman Catholic marriage, which was not in compliance with the Marriage Act. It was contended on behalf of the respondent that the court had no jurisdiction to entertain the petition, as the marriage was performed solely in accordance with the rites of Roman Catholic Church, without compliance with the requirements of the Marriage Act. It was further argued that the marriage, which was celebrated without the necessary registrar's certificate, was void. However, the court held that if the intention of the parties was to get married under the ordinance, and they believed that they went through a form of marriage recognized by the law, then if the marriage had been performed in a place of worship licensed under the ordinance of the purpose, the marriage was, in my view, would not be void, merely by the reason of non-compliance. I hope you get that. Unless it is or it was affirmatively shown that the parties willfully and knowingly failed to comply with the said sections, that's the section 11 and section 13 of the Marriage Act. So the judge found that the petitioner had no knowledge of the legal requirements of a valid marriage, and it was her intention, and I believe that she was going through a marriage recognized by both the church and the law, that is the act. So it could therefore be held that she willfully and knowingly acquiesced in it could not therefore be heard that she willfully and knowingly go on with the irregularity intended by her husband and the officiating minister. It was held that her marriage was valid and the court had jurisdiction to dissolve the marriage. Another thing I want us to look at is when the marriage is not celebrated by a recognized minister of religion or a register of marriages. Now, under the Marriage Act, any marriage that is celebrated under it must be celebrated either by a recognized minister of a religious denomination, a pastor, a bishop, a prophet, or a body, or by a register of marriages. Non-compliance with the requirements makes the marriage void ab initio under the Marriage Act. So for you to successfully say that your marriage is void, the marriage must be celebrated by a recognized minister of a religious denomination or body, not with a minister of God that is not a minister of any denomination that is not recognized. Another one we like to look at is lack of real consent. Like for there to be a valid marriage, this is straight to the point. There must be consent by both parties. Now, it is a cardinal principle in our law that the parties to a marriage must have freely consented to the union. Absence of consent will invalidate any marriage. Or where there is apparent consent and a party did not actually give a real consent, it will be negated by various functions. Number one, if the consent was gotten by fraud or duress. Where the consent of one party to a marriage was obtained by duress or by fraud, the marriage will be void because it lacked the consent of one of the parties. And any marriage conducted under fraud or duress, according to section 31, section 3 sub 1 sub DI of the Matrimonial Causes Act of 1970, duress or fraud may violate consent. Now, fraud here implies some dishonest or misrepresentation to the other party in a marriage, by which their consent was obtained by, misrepresenting to them or telling a lie. So duress is such a compulsion that usually affects the mental capacity of the other parties or the mental attitude of the other party. So it has to be shown that the duress created a state of fear or apprehension which prevented the other party from freely consenting to the marriage. There must be no willful or free consent. Duress must actually be seen to have been, duress must seem to have been present when the other party was giving their consent or fraud. Another thing is mistake. This is very common. So this is where the other party does not give their real consent because they are seeing they've mistaken their other party to be as they've seen their other party in another identity, in identity of another person. Now, mistaken identity will invalidate a marriage where a person desires to marry a party but in fact married another person. So we must put into consideration that mistake is when you want to get married to another person and there has been mistake as to the identity of that person, as to who the person really is. So an action will however fail if the mistake is to the attribute and not to the identity. Now, this is another form. For example, in a situation whereby the person has told you that he is wealthy and you find out after the marriage that he is not wealthy, the court will not say there is a mistake because the mistake has to be as to the identity of that person, not to the attributes of that person. Another one I want us to look at is insanity. A marriage is null and void where the consent of the parties is not real because the party is mentally incapable of understanding the nature of the marriage contract. And this is section 3 sub 1 sub D sub 3 of the Matrimonial Causes Act of 1970. When a person is insane, anyone considered as insane is not able to make decisions for themselves, cannot think through for themselves. Their thinking faculty is affected. So when a person is insane, they cannot give their consent. Any marriage that is contracted with an insane person is void ab initio, void from the beginning, because we believe that their consent is not given willfully. Another one is a marriageable age. Now, any marriage is null and void if either of the parties is not of a marriageable age. However, there is a lacuna in the law, the Marriage Act of Nigeria, because it is not giving a specific age of what a marriage. It is not giving us a specific number of what a marriageable age is. But however, this is a lacuna in the law that needs to be fixed. So however, it has been resulted that we should focus on what the common law says about age of marriage and all that. Another one that I want to talk about in concluding is that for a marriage to be valid, the formalities that I stated, I've been stating for quite some time, they are very important. Those formalities must actually be complied with, because if the condition precedent for a valid marriage is not complied with, the marriage is void ab initio. If they are not of a marriageable age, if there is no consent, if there has been an existing marriage, the marriage will be void. If the person is insane, the marriage will be void ab initio. So if you want to know if your marriage is void or voidable, check those things. Like if your marriage is actually, maybe your consent was gotten by fraud, by mistake, by duress, or probably when you were not mentally okay, your marriage is void. That is what the law says. And I really hope I have done justice to what void and voidable marriage is. Do not forget to subscribe to my YouTube channel, turn on your post notification to get full content, to get more content about what the law says about your marriage. Bye for now.